Oh, Jen, you cut out on me. Are you able, is there? Okay. All right. Well, I'm Nicole Gorowski. I'm the co-chair of the NCJW Lunch and Learns. And today we have a great speaker. It's Sarah Jane Hunt. And I would like to recommend Sarah Jane Hunt to anybody who has any issues in the community with special needs in any way. So Sarah Jane is a civil rights attorney at the law firm of Kennedy Hunt. Her specialty is in disability rights. And she does disability rights in a number of forms. If it comes into employment discrimination for disability issues, if it comes into students' rights and special education, she does that. If it comes into play in fair housing issues, she does that. So I want everyone to enjoy Sarah Jane Hunt today.
Hi, everybody. Thank you, Nikki, for that introduction. All of those things are very true. I'm going to try to share my screen, see how this goes. Sharing it. Okay, so I'm going to leave it in this format because every time I try to actually do the slide, then I can't see anyone anymore. So I am an attorney in the St. Louis area. We do focus on discrimination laws in general across a variety of protected classes. And I'll talk to you a little bit about what that means to be in a protected class. But as Nikki stated, what tends, the cases that tend to come across my desk are cases involving individuals with disabilities. And those disabilities could be—
I think your PowerPoint went away, or it like got minimized or something from the screen that you're sharing now.
I don't know. Let me see.
All I can see is it like your Zoom pop up.
Okay, let me see. I don't know why. It should only be doing— is it back? Is it better here?
Now it's back.
Okay. Okay. Let me make this a little smaller though. Sorry. Should have. Alrighty. So the cases that tend to cross my desk are cases involving individuals with disabilities. And as we learn more about disabilities and the different types of disabilities, the cases can become a lot more expansive. For instance, you know, there was a time when many people just believed that if you didn't have a physical disability, that it wasn't really one worth accommodating. But now the disability categories have expanded and include not just a physical disability, but developmental disabilities and mental disabilities. The other category that is becoming something that I am becoming involved in a lot more litigation is related to substance use disorder. Under the ADA and the Fair Housing Act and local human rights laws, an individual who is in recovery from a substance use disorder is also protected under those acts. And how that comes up in my daily life and my practice right now is relating to litigation of sober homes and various municipalities that attempt to shut them down. I can chat about that specifically later. And then also in the workplace, people might need some accommodations related to their recovery, including maybe having a little bit of a flexible work time so that they could go to meetings or to therapy or things like that, that those are starting to become a lot more common. I think because we're starting to talk about addiction along the lines of a mental health diagnosis and not just something that we think of as this voluntary action that is really only to be dealt with by forms of punishment. So echoing what Nikki said, this can come up in a lot of different ways as far as discrimination. It can come up in employment, housing, and places of public accommodation. And typically where we see places of public accommodation are schools. So I have a lot of cases involving discrimination in public schools. There are some laws that apply to private schools, but it is getting to be much harder because most private schools have a religious affiliation. And under the Missouri Human Rights Act, under the most recent amendments, they have exempted all religious schools from the Missouri Human Rights Act. So these are laws that you've probably heard of a lot: the Americans with Disabilities Act, the Age Discrimination in Employment Act, Title VII, Title IX, whistleblower laws. One you might not have heard of that I deal with quite a bit is the Individuals with Disabilities Education Act. And where that comes into play is in public schools where there are children who are perhaps not getting the services that they are entitled to under the law, or perhaps it's they're refusing to provide them at all, or it might be a question of whether they're providing adequate services. So that is a unique area of law that my firm does. And I think I only know of one other private law firm in the state that does those cases. Then we have the Fair Housing Act. And so the reason why we tend to represent people with disabilities is because this started with my law partner, who years ago got involved in cases under the Individuals with Disabilities in Education Act. And he started by representing those children who needed services and their families. And then as those children aged and were out of the school system, they had a multitude of other issues relating to their employment, relating to housing, that then the practice just kind of evolved from there. The state laws that you might look at that have these same protections is the Missouri Human Rights Act. And we also practice in Illinois. So we practice under the Illinois Human Rights Act. And then both states have whistleblower protection laws. We also do, just to keep it interesting, wage and hour law, which is when people are not being paid properly under either the state laws or the federal laws. And while it might seem that these practice areas are kind of don't have anything to do with each other, they really do, which is just this sense of injustice that anyone who works in my firm just can't stomach. And they sort of build on each other. A lot of times with the wage and hour cases, other firms that do discrimination don't really see it as a civil rights issue or a discrimination issue, but the people I tend to represent tend to be people of color, people who don't have great socioeconomic status, women who are kind of boxed into these jobs and really need the work. And so they get taken advantage of. A lot of my Fair Labor Standards Act cases also involve people without legal status. And once again, they're just vulnerable populations that really just, signed up to do a construction job, and they're not getting paid their wages. They're not getting paid overtime. And anytime they complain, the employers threaten to report them to ICE. So even though that the laws I'm talking about seem kind of varied, really there's a theme in the work we do, which is really trying to represent people who can't represent themselves, and fighting for a stage of dignity and just basic rights. It's really not that hard to pay the minimum wage. It's really not that high, or follow the overtime laws, which is if you work over 40 hours a week, you should get overtime for most job populations. And when you don't, that tends to be because sometimes it's really just an employer overlooking or not understanding the law. That definitely happens. But other times it's really this power dynamic of, what are you going to do about it? You're not important. I'm powerful. I'm going to pay you how you want. And if you complain, you're not going to have a job. So those are sort of the populations of people that we tend to represent. In the discrimination context, discrimination, you probably hear it quite a bit, and I've heard it quite a bit over the past couple years about what people think is discriminatory and what people think is a violation of their, quote, civil rights. And often our view and society's view of what is protected is just not. It is totally legal for your boss to be a complete jerk. That is not something I can do anything about. Universal jerks, not something I can do anything about. What has to occur is that they are treating you unfairly or in a discriminatory way based off of some type of protected status. And the protected status under most of the federal acts are race, religion, sex, sexual harassment, national origin, age, disability. And then there's a unique category under the Fair Housing Act, which is familial status. And what that means is essentially you can't relegate women and children to, the worst apartments in an apartment building, that you have to treat people based on familial status equally. And that's only in the employment context. Things that you probably also hear all the time are, I'm being persecuted because of my political views. Under most state laws and under federal law, you are not protected for your political views unless you are a public employee. So the First Amendment applies to governments. And so if you work for a government and are treated poorly because of your First Amendment views, you might have a cause of action, though over the course of the years, the Supreme Court has made those cases pretty difficult. But that's something I get a lot, where people think that they have a First Amendment right in private employment, and they don't. There are some states, none of them that surround us that I know of, that do protect political views, but not Missouri and not Illinois. One thing too that I like to caveat is sexual orientation is also at this time not completely covered, though it's a little confusing because there is a Title VII case. Title VII applies to employment that did extend protection, but it remains to be seen whether or not that same line of legal reasoning is going to be applied to like the Fair Housing Act or the ADA. And we have some state cases where there have been protections extended to individuals who are transgender and individuals who are gay and bisexual, but they've kind of done a legal dance in doing so that I won't really get into. We still have not come out in the state of Missouri. We still have not come out and said you are protected based on who you love or based on your if you're transgender or your gender identity. So how this manifests most of the time is in our employment sense. We have a couple different ways that employment cases tend to manifest. Most of the time, I get a call because someone has been terminated. And many of the cases that come across our desk are for a lot of different reasons, and most of them are not anything we can do anything about. And then even the ones we can do something about, the states and the federal agencies have just made it really hard on employees who even have a good claim to continue with a preserved complaint. And so what I mean by that, I'm kind of going rogue, this is a little bit further down in my presentation, is I tell everybody who calls me, if you go get hit by a car in a parking lot, you could sue the driver the next day in court. You cannot do that in most employment contexts. In any type of employment discrimination context, you cannot just go file a lawsuit. In the state of Missouri, you have to file a charge of discrimination to preserve your state claims, which are by far your best claims in this state. And I won't go into all the reasons why, but essentially you're going to find a venue that is a little more sympathetic to plaintiffs in the state cases. So you have 6 months from the last act of discrimination to file a charge of discrimination with the Missouri Commission on Human Rights. Good luck finding that form because it's not online. You have to call the agency and ask for it, whereby they tend to put you through this questionnaire process that might be helpful, but if you're looking at you're calling on the 175th day, you really just need to get your charge filed. And nobody who at intake is really telling you when your statute of limitations runs because they haven't heard your claim yet. So it's this very confusing process by which you need to get the charge on file. You do not need a lawyer to do it. If you can get to an attorney quickly, most of the time we will help with that process. And then what happens is it just sits there. The state under the human rights amendments has also made it so that the state agency has to hold your charge for 180 days before it releases it. And so what this looks like is let's pretend you get fired. You have 6 months to realize you've been fired for a wrong and discriminatory reason, find a lawyer who will take your case, or on your own, file a charge with the state agency to preserve your claims. If you do not file that charge, you can never, ever pursue a lawsuit. Meanwhile, while all that's happening, there's an overall 2-year statute of limitations by which you have to get it into court, which is kind of frustrating because you don't really have any control of what's going on with your charge when it's with the commission. So the commission holds it for 6 months. What's supposed to happen is they're supposed to investigate and determine whether or not discrimination has occurred. But while everybody's very interested in holding up these kind of impossible timelines, no one's actually interested in funding the agency that's supposed to be doing these investigations. And so sometimes as lawyers, we get frustrated with the Missouri Commission. However, I try to remind myself that these are people who are told to do a job without given the resources they need to do the job. And so what tends to happen is nothing happens. Your case just sits there for 6 months. And if anyone, I'm sure whether or not you know the law, or know someone who practices litigation, it's kind of important to get all the statements and all the evidence and everything you need sort of close to the time that what you are claiming occurred. But as an employee in Missouri, you don't have a right to your employment file. So most of the time, the only way you can get those documents is if you file a lawsuit, which can't happen for at least 6 months. 6 months from the time you file your charge. So if you don't file a charge until 6 months, they hold it for 6 months. You're looking at about a year being filed in court from the time the act occurred. And as you can see, that's done, I believe that is done on purpose. I think that there are so many barriers that are put up for people to get their claims heard, and this is one of them. There's also a federal equivalent, which is the EEOC, which I'm sure all of us have heard about. You do have 300 days to file with the EEOC. However, if you don't file within 180 days, then you waive all your state claims. And no one tells you that when you're trying to figure out what office to call. So again, we spend a lot of our time navigating or just telling people like, you called us too late. We can't do anything because you didn't get to us in time to file a charge. Or sometimes people are very knowledgeable and they call us before anything bad has happened. They just think something bad is going to happen. And even then we have to say, you called us too early. We can't do anything about it. But I'd much rather be in that situation than in a situation where someone calls me 181 days after they're fired and there is no way to get it back. It's not one way. So wrongful termination, like I said, is the most, the biggest reason people call us. And sometimes it can happen because they want to hire, like in age discrimination case, they've determined that because of a certain person has reached a certain age, they no longer want them. They want someone younger. And sometimes I have to tell you, sometimes they say that and then they fire them and then they hire someone younger. Sometimes, a lot of times what'll happen is they'll claim that they're eliminating the position. They eliminate the position for like a week and then get rid of the employee and then hire a 20-year-old in their place about a week later. So that's direct discrimination based on a protected class. The other thing that can also happen is a retaliatory discharge, which is in the same scenario, somebody is being told, you know, a lot of comments are being made about their age and that they can't keep up and that they really just need someone younger to do this job. They make all of these comments, and then let's say that employee complains to HR about those comments, and then they are terminated. So it can be based on an actual protected trait, or it can be based on a complaint that you're being discriminated against, or someone else is being discriminated against if you're advocating on behalf of someone else. So I also hear a lot people calling and thinking they're being retaliated against. And that might be that people are kind of rude to them, or, you know, they got written up, things like that. What the law defines as retaliation is an actual adverse employment action. And what that looks like is a demotion or a termination, or making your job so terrible that you actually can't do your job. But things like, I just feel like I'm being retaliated against, or people are just kind of a little bit different, or suddenly I'm getting write-ups, or now I'm on a performance improvement plan. Those aren't quite to the level of retaliation. Now, I usually tell someone it's coming at that point. It will come, it will happen. So be prepared, know what your deadlines are, but there has to be an actual act taken by the employer that is defined as adverse. Trying to move. We also handle sexual harassment in the workplace, where it can happen in a couple different ways, where someone is being asked to perform sexual favors in lieu or in exchange for some for their ability to maintain their job, perhaps, or to get a promotion. That's something that's called quid pro quo sexual harassment. What I don't see that as much as the hostile work environment claims. And again, a lot of people talk about hostile work environment, that it's a word that's used a lot. And it's an example of kind of how far the law is from where we are in real life. I have many cases that I've tried to push forward where it's been completely inappropriate what is going on in the workplace. And the court just didn't think that it arose to the legal standard that has been assigned to a hostile work environment. So the rule is severe or pervasive conduct. But in reality, the courts tend to say that it needs to be severe and pervasive. I had a client whose case did not make it past motions, who was on 3 occasions, her supervisor made pretty explicit comments about his genitals to her. And yet that was, you know, I think the court used, while wildly inappropriate, does not rise to the standard of severe or pervasiveness. Some courts, even if there's contact, even if you're kissed, unwanted kissing, if it only happened once, really, does that rise to a hostile work environment? I think we would all say in this group, I don't know you all, but I know Nikki quite well, and I know the company she keeps. And I would think that all of you would say one time is too many times, right? Society is getting to a point where I think we're starting to get there. But this is an area specifically that sort of breaks my heart, despite my attempts to push the law a little bit closer to where we are. It's just not there. Not to say that I won't keep trying, but it has to be pretty horrendous conduct for it to get across that bar. Does anyone have any questions so far? I know I'm giving a lot of contact. Okay. So this is actually a slide that I used in a training for some intake I was doing, but I think it's helpful to hear sort of the questions that we ask when people call us. So if this comes across up in your life, you can ask the same questions, which is, you know, I'll get someone who calls and says, you know, well, I'm a woman and I was fired, so I'm calling you. And I'm like, okay, that's a place to start, but we need a lot more information before we know if there's any case here. And some of the questions that are really helpful to ask are like, why do you think, like specifically, why do you think you're fired? I'm not interested in why they fired you or why they said they fired you. I don't have a lot of cases where they said, I'm firing you because you're a woman, or I'm firing you because you're Black, or I'm firing you because you're too old. Now, I will say, I do have cases where that happens. There are some people who are so blatant that they do say that. But for the most part, they come up with some other reason to terminate, or to demote, or for whatever conduct it is they're doing. And so we start to ask those questions. Why do you think you were terminated? And from their perspective, once you start to get that information, it helps a lot more. Well, they say, and also what I should say too is most people, and this is regardless of ideology or socioeconomic status, most people just don't want to believe that it occurred because of a illegal reason. So even though they're calling me, they feel like something happened. Sometimes it takes even a couple go rounds before we can get to the point that they're trying to make, which is, well, you know, I don't know if it was because I was pregnant, but, you know, I was like employee of the year. I got a raise every 6 months. I was up for a promotion, and then I told them I was pregnant, and the next day I got demoted. And it's like, okay, you're right. Like, did they say that was the reason? No, but that's pretty good evidence that something was up. And we start to talk from there. Or, you know, my boss never said anything about, you know, me having multiple sclerosis, but he really made fun of me using a cane and made fun of the shoes I had to wear because I couldn't put on high heels. And actually they, you know, after they found out I had multiple sclerosis, they made a company-wide policy that you couldn't wear tennis shoes and everybody had to wear high heels. So those types of anecdotes are helpful to me to kind of get to the place of, okay, so yes, nobody said it outright that they're making fun of you because you have MS, but the other things you're telling me are at least a brick in the wall of evidence that that might be some of the motivation for their treatment. Other things too are just comparative treatment too. This happens with women a lot, especially women. I got into this sort of, in addition to working with a lot of people with disabilities, I started getting a lot of cases of women who work in law enforcement. And that's not just police officers, but people who work at the front desk or people who work for the dispatch. And it might shock you to learn that there are a lot of claims, especially in the smaller towns, of women who are being subjected to some pretty heinous working conditions. Their coworker, for instance, was let off work for 3 months for back surgery, but when they needed like an extra month off because of pregnancy related complications, that was a no-go. So also just looking at how am I being treated compared to people who might not be in my protected class. Those are other kind of things we look at. And so this is the spiel I tell everyone about termination. The other thing is that, everybody calls me and says, oh, well, I know we're at will state. So that means I can't do anything. Well, I mean, I actually don't know of any state that's not an at will state. What that means is, generally speaking, an employer can fire you for any reason or no reason at all, unless it's an illegal reason. And if it's an illegal reason, it would be because they made an adverse employment decision based off of one of those protected statuses that I indicated earlier. So if they don't like, if they just don't like that you wore red, they could fire you. Or if they don't like the way you organize your papers, they could fire you. But if they're requiring you to do something differently because of a protected status, or they find out that you're a member of a protected status and start treating you differently, then there is something that can be done about it. I'm not going to go through all of these, but a couple of the things that I see too is just kind of distinguishing what's unfair and what's illegal. I hear a lot of really unfair things that happen, and my heart goes out to those people, but it doesn't make it illegal. For instance, if they, they have a policy that says, you have to be written up, or first a verbal, then a write-up, and then you get fired, but they went straight to firing you. Unless there's something I can point to that was done based off of a protected status, it's unfortunate, but it's not illegal. Or the one I hear a lot too is like in Missouri, when they fire you, you do not have to be given any reason. Now, there is something in Missouri that's the service statute, which you can write a service letter to certain corporations and ask for the reason for your termination, and then they have to give it to you in writing. But at the time of your termination, they don't have to give you any reason. I already went through these timelines, so I'm not going to go through them again. And they're not really, I'm not asking you to memorize them. I think my point in bringing them up was just to show and highlight how many hurdles have been put in front of people who are trying to get justice for things that have happened to them. And why, if you hear of anyone who you think might have a claim or might have had any of these types of discriminatory behavior occur, that you should tell them to run, don't walk, and find a lawyer, because 6 months seems like a long time in certain situations, but it certainly isn't in this situation. I kind of wanted to jump to some fair housing examples, just because I love the Fair Housing Act. It's one of my favorite types of cases to do. But before I did that, does anyone have questions about the discrimination in an employment context?
There was kind of a question in the chat. We were talking about MONA, the Missouri Non-Discrimination Act, which NCJW has been working on for several years trying to get passed. And we did help pass some of those, some legislation in the small communities around St. Louis, like Creve Coeur. And Nancy Price, who lives in Kirkwood, said that there's one there. Now, would that hold up in court, or because the state doesn't have that law, will it not?
So
If I'm making any sense.
So I'm not really sure what the legs or like the bite to those statutes are. I haven't had a chance
Okay.
to look at them. But what I can say is, as far as Missouri, like what I can file in circuit court, which is your trial courts based on where you live and the circuit in which you live in, they don't have a lot of legwork there. For instance, we did try, I think years ago, to say under the Whistleblower Act. So in addition to what we have here, which is the discrimination, there's also what are called whistleblower claims, which are, okay, you're not following the law and you're asking me not to follow the law, and I'm not going to do that. And then you get fired. When it's a law, a state law, it's pretty clear that that falls under the Whistleblower Act. But there has been case law that suggests that local ordinances are not considered public policy for the purpose of that act. I'm not sure if I'm making any sense, but basically you can't say, oh, you didn't follow this local ordinance and you're asking me not to follow it, so I'm not going to do it, and then you get fired. You're not protected under the state Whistleblower Act for that. What would have to happen would be there be some true consequence written into the local ordinance that I guess the local municipality would carry out, maybe their own council, you know, like they usually have their own like the circuit, the city attorney in St. Louis, or whoever the civil side of things would be in each municipality. But I still think they're important, even if, you know, I can't file a lawsuit about them, because it shows well, one, I think that the judges might eventually get there in our courts, and it also just shows the community, you know, what you stand for as a municipality. And I think it's really important. Like, for instance, gender, I think sexual orientation, I'm not sure if identity is included because it was such a long time ago, but I know that in St. Louis County, that's been protected for a while. And it has come up in dicta in certain cases, but which is helpful, even if it's not the home run we want it to be. So in addition to employment, I guess I should talk to you a little bit about how this manifests in a place of public accommodation. So these standards are pretty much the same, whether it's employment or a place of a public accommodation. It's just a little bit different because we're not talking about adverse employment actions, anything like that. So Nikki and I used to do some cases together involving you know, children who'd been sexually assaulted or harassed by teachers or people of power in the school system. And Title IX has become an increasingly hostile place to be in federal court. They're just making it harder and harder to get any kind of relief under those acts. And what I mean by that is money, which sounds really uncouth, but it is the only thing you can get under these types of acts. And it's becoming harder and harder to get damages in those cases, which means it's getting harder and harder for any lawyer to take those cases. So as that's been occurring, I've been really trying to think about how the Missouri Human Rights Act could potentially address some of these issues, and it does. There's not as much case law on it, but there have been cases recently that say that schools are subject to the Missouri Human Rights Act, and therefore, if you know, teachers are harassing or assaulting students, then and we can tie it to sex, then we start to file cases for discrimination in places of public accommodation under the Missouri Human Rights Act, just like we would in the employment context. Those cases are a little bit harder because, you know, You're usually dealing with a parent as a proxy because the children obviously don't have standing to bring their own cases. And then usually, because you're still trying to fit into those timelines, you're dealing with people who are actively going through the trauma of what occurred. And then while sort of trying to preserve their rights under the law so they can get some kind of damages and some kind of justice for what happened to them. So that happens. I do those cases based on sexual harassment. And then I also have some cases where kids who have disabilities, I have one case right now, for instance, where the school just refuses to recognize mental health diagnoses as anything that they need to deal with, which is an example of discriminating based on type of disability, which is also discrimination. So, saying we'll serve people who have a physical disability, or we'll serve people who have developmental disability like autism. But if you have manic depressive disorder that is affecting how you learn, that's not our problem. So we take cases in that regard too. And like I said, it seems like we do a lot. We really do, but they really all actually sort of just build on each other, and the law is not that different. And sort of the motto of the firm is, help as many people as you can without going broke. So, we do have to make some money on these cases to keep our lights on and to pay my employees. But the real hope is to help as many people as you can, because especially when you get these calls and they might have talked to 5 different people who have no idea what they're talking about or have no clue how to even help them. And then they finally get to you, and, you have some semblance of what to do in this situation. You really feel like you are acting as a guide in a really awful time in most people's lives. And we can't take every case, obviously. We turn away way more than we take, but we do try to find a way to help people if they fit into this sort of niche that we do. I'm going to talk just a little bit about the Fair Housing Act, and while it sounds like a big jump, it's really not. And if you look at the kind of the origin of the Fair Housing Act, it's really fascinating. So it was signed into law in 1968 by President Johnson. It's interesting to me that the quote he said while signing it is still very true today, which is, "We have come some of the way, not near all of it. There is much to do yet." And the Fair Housing Act was actually signed into law 2 weeks, just a singular week after the assassination of Dr. King. It expanded on the rights that were put into place by the Civil Rights Act of 1964 and the Voting Rights Act of 1965. And made it unlawful to intimidate, threaten, or interfere with any person in the exercise or enjoyment of any right granted or protected by the Fair Housing Act. It was later amended in the 70s, 1974, to include gender, and then in 88 to include individuals with disabilities and families. So again, we're talking about these protected classes, which really are the same for the most part as they are in the employment and the place of accommodation context. Again, the only difference is familial status is addressed here. So this is really small writing. I'm so sorry. I tried to mess with it and it just kept going rogue on me. So I'll just go from memory on what's prohibited, but a lot of things are prohibited under the Fair Housing Act. The Fair Housing Act has not been as attacked and gutted as the Civil Rights Act and the Voting Rights Act. I don't know why. I think it's just because there's not that much litigation. Like my special education practice, there's just not that many lawyers that do this. So these cases don't come before the courts all that often. And when they do, those of us who take them are very, very picky about the cases so that we can try to preserve the law that we have and not have it walked back. I'm sure you all know that the landscape of our our judges in federal court has changed over the past several years. And given that they're all lifetime appointees, that's probably not going to change for a while. So we have to be really thoughtful about the cases that we bring. So there's a lot of different ways that you can violate the Fair Housing Act. It can be based off of refusing to rent altogether, putting different conditions on renting or selling for some people that you don't do for others. I don't do these cases. They tend to be done by the Department of Justice or these really big law firms out of DC, but also discriminating in how loans are awarded for housing and mortgages, discrimination in appraising properties. I say all this, there are a lot of different, also just like landlord tenant, in the sense that you have, I see a lot of cases where landlords are sexually harassing tenants and requiring quid pro quo acts before certain things are done to apartments, or threatening to evict people if they don't do what they want, those types of things. Where my practice is growing is what I talked about earlier, which is in, when I first started 10 years ago doing fair housing cases. Now my law partner's been doing them since the 70s, but I started doing them relating to individuals with developmental disabilities that live in community housing. So you all might have one of these homes on your street. You wouldn't even know if you did. It would tend to be people who have autism or Down syndrome, whose parents are no longer able to take care of them or perhaps have passed on. And they live in, usually homes with 3 other people with disabilities, and they have aides that take care of them. But the goal is to not institutionalize people. After Olmstead, the Olmstead case, which basically said that saying that you can live here, but you can't live there, is a lot like saying you can sit in this part of the bus, but you can't sit in that part of the bus. Just putting someone, relegating them to an institution because they have a disability, not only is illegal and discriminatory, but I think where it caught the ear of some of the more conservative justices is that it's also incredibly expensive. And so as long as it is cheaper for you to live in the community, that you should have access to community housing and not institutionalization. So that's where I do a lot of my work. I just tried a case in Springfield, Illinois, relating to 3 gentlemen who lived in a home for 3 years. You can't see anything. There's nothing to note that the home is a group home. The city got sideways on it and tried to kick them out until we got an injunction to stop it. The ways that the municipalities tend to do this is they try to say, well, there's more than 3 unrelated people living in a house together, and our zoning prohibits that. But under the Fair Housing Act, in addition to all of these other protected activities in here that are prohibited activities, is they also have to make reasonable accommodations to their laws, rules, and policies, so long as it's not an undue burden on the municipality or that it's not a fundamental alteration of the program. And as you can imagine, if you have 3 guys who've been living in a house for 3 years, then no one ever noticed. They don't use any of the public services any more than anyone else. There are no police calls. It's impossible for the city to say that it's some undue burden. So in that case, they claimed that there were, first of all, there were less than, so their ordinance said 4 unrelated people. We had 3. But they said, but because you're disabled, you can't, that doesn't apply to you. You're really like this group home. And because you're that, you can't live within a certain amount of feet to another group home, and you do. So you have to go, you're just being shut down. We asked for a reasonable accommodation. They ignored it. We sued. We won. So that's been sort of the landscape of disability housing for a long time, in addition to asking for reasonable modifications, which are different than reasonable accommodations. Modifications are, for instance, as I understand it, our state capitol is not accessible. It seems like there would be a lawsuit for that. No one's called me, but if they did, I'd probably look into it, that we have a state facility that does not and this would actually be under the ADA, but they're similar, that is not accessible, and it should be. How it works in housing is usually in the landlord-tenant sense, or I've had a case where they needed a ramp in a home they owned, and the homeowners association was giving them a really hard time. And just sort of, like I said, where the trend is going and where I'm getting more and more cases are these sober homes, where they're a lot like the group homes I'm telling you about. Sober homes are for people who are not in a halfway house. They're not in a 3/3 house. They're not an outpatient. They are literally at the last step of their recovery before they're supposed to go back to their families. And it's a time for them to learn to live in sobriety as a family with other members of people who are in recovery. And we're getting a lot of the same discriminatory actions. Municipalities just can't. I actually have a case right now where they exclude people from, they say people who are have substance use disorder can't live in residential housing. That is just an outright, you can't do that. Okay, if any of you are writing ordinances for your municipalities, that's a really bad idea. Because again, you're saying if you have this kind of disability, you can live here, but if you have that kind of disability, you can't, which is discrimination on its face. So this is where my practice is taking me a lot more, while the other members of my firm are handling a lot of the employment case, because it's coming up more and more, and this is actually happening nationally. So I'm going to Arizona, I'm really going to a lot of places in the Chicago suburbs that really don't like these homes, and Kansas City, all over the place. So I will stop there. I could go into the IDEA, but that would just be a whole other can of worms. And I only have, I think, like 5 minutes left. So I thought maybe we should leave time for questions.
Sarah, I have a question.
Yeah.
It's Nikki.
Hi.
So I don't know if you read this article. There's been an article recently, I think either on CNN or in the New York Times, about they interviewed some doctors, and the doctors, they let them be anonymous, and the doctors all started talking about how they don't want disabled people coming into their medical practices, and that they're just not, they're telling them basically, you might want to make an appointment somewhere else, or we're not equipped for your wheelchair, and things like that. I don't know if anyone else has read this.
Oh my gosh.
I know. What would that fall under? Would that be what would
that would be
fall?
a place of a public, well, one, it would be a place of a public accommodation, and it potentially, if they take any type of federal funding like Medicare, Medicaid, could be a violation of Section 504 of the Rehabilitation Act, which was a precursor to the ADA that was written when all of our vets got back from Vietnam and nobody would hire them. So it applies. It's essentially a lot like the ADA, but for federal, anybody who takes federal money. So there are a lot of different problems with that. I would say under the ADA, it would definitely fall under, if they're in Illinois or Missouri, it would fall under the Missouri Human Rights Act or the Illinois Human Rights Act. Also, yeah, if they're taking any type of federal money, they could probably be penalized by CMS, because I think you have to subscribe to a non-discrimination policy to participate in any type of federal programming. And that's just the discrimination on those grounds. To the extent that they're not wheelchair accessible, that could potentially be an ADA violation for failure. It would depend on where they were, how old the building was and stuff, but that could also be a problem. But that's horrible. Any other questions?
Well, if there are no other questions, I think we'll go ahead and wrap up. Sarah, thank you so much. This was so informative. And this is stuff that people don't think about that is happening to real people every day. And we need to do all we can to support those who are in these situations. I cannot thank you enough. And we are going to have a little gift for you coming in a few minutes. So just an appreciation of you speaking with us today. Nikki, do you have any announcements that you'd like to make before I wrap this up?
I don't think I do.
Okay. Well, thank you as always. Nicole has been our lunch and learn coach or lunch and learn chair for this whole year, and she has agreed to stay on for next year. So we are so thrilled about that because she has such great ideas. If anyone has any ideas that they'd like to see for a lunch and learn, please shoot me an email. Also remember that we have our weekly 5 Ways to Advocate e-blast that comes out every Monday. If you are interested in what we do at NCJW and just want to hear what's going on in the world of advocacy, shoot me an email. I will be sending out an email after this with an evaluation. So you can just reply to me and let me know if you're not already receiving that and you would like to. And be sure and join us next month. We are having the NCJW liaison in Israel talk about our programs and projects that we do there with everyone in the country. It's all social service agencies, nothing to do with the government or anything like that. And we have some amazing programs basically working to help improve the lives of women, children, and families there as well. If there are no other questions, I think we will wrap up and we'll see you next month. So thank you so much.
Thank you.
Take care,
Thank you.
everyone.
Thank you.